Yeah. You have to keep the tree.
Here it is. Oh, this is just.
And it's safe.
So it's, I mean, that's gonna be great.
Yeah.
So at some point in time,
Three things that have the most evidence.
yes.
No, my husband's family was
But it
Greenville
can
Turner,
happen.
so.
Not that it's a big deal,
Delta
but
Turner.
it can happen. If you've ever had any of those. Take what you can get.
Oh, well, we hadn't called the meeting to order yet. I was just giving you a
Okay.
chance to set up. Mhm.
Okay.
Are you good to go? Are you ready?
Yeah, y'all want everything to start now? I think.
No, we'll just. Well, yeah, I think. I'm like to call the meeting of the State Board of Medical Licensure to order. And we will proceed with the agenda as printed. So at this time, if you will all stand, and we will have Dr. Tom Joyner lead us in our invocation, and Dr. Kennard will lead us in the pledge.
Please bow your heads. Almighty God, the divine healer, we give thanks for the many blessings you have bestowed upon us. And we give thanks for the opportunity of eternal life through your Son, Jesus Christ. We ask that you be with us today in our deliberations so that we may better serve the citizens of Mississippi and the physicians of Mississippi. In Jesus' name we pray.
Amen. Thanks, Tom. Stand and face the flag. Attention. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, I'd like to acknowledge our guest today. Our representative from the Attorney General's office is Ms. Kim Turner, and our court reporter for today is Ms. Shanna Cumberland. At this time, we'd like to open the floor for public comment. Hearing none, we will proceed with the executive director's report.
Thank you. In licensure, in July and August, we issued 135 new MDDO licenses. That's from direct application, no new podiatrists, and 20 PA new licenses. Through the compact, we actually issued an additional 291 licenses, and we provided letters of qualifications for 16 licenses. Certifications to other states is 336. Investigations, we received 104 complaints, closed 14 cases, opened 24 new cases, which increased our total cases open to 80. We still have a very high percentage of cases closed within 7 days, although it fell off a little bit. Last report was 93%, it's 85%. We requested 84 PMP reports, 48 of those resulted in continued investigation. And then I'll just give my usual message about to the committee chairs to really look at your committee and think about whether you need to be having meetings between each board date meeting and schedule those 3 meetings. With that, I'll take any questions. Oh, yeah, I would. As a side note, I guess, I met with OLRC, Paul and I, and Jonathan and I met with OLRC yesterday, and they approved our changes to PA regulations. And they also approved our changes to the medical cannabis regulations.
So the PA regulations is what we did before with the changes to the CMEs and all those things. Is that correct?
It was more to do with the actual
And the
having
cycle.
to submit the supervisory agreement and having it board approved prior to being able to practice. Now they just have to have an agreement on file in their office for a board investigator should they come by. They don't have to submit it in advance to us anymore. But that also, we had to bring in the 75-mile limit since we weren't previewing them.
Okay.
So, yeah.
Thanks for that clarification. And from your executive director's report, when we give the statistics on closure within 7 days, is that like within a week of, or is it business days? And is it business or?
Complaints that come in, I mean, you know, within 7 business days.
Perfect. That's just wanted to clarify. All right. At this point, we will move to the next items, which are approval of our minutes. There are several copies of minutes from July meetings, both of the executive committee and the full board, as well as the special call board meeting in August that are prepared for you in your binders. And so hopefully you've had an opportunity to review them. If not, please take a look at them right now, and if there are any corrections or anything, please make them known. And at the completion of your review, I will entertain separate motions for approval of each of the sets of minutes provided.
I move, when you ready?
All right.
I move we approve the executive committee dated July 26, 2023.
Okay.
We have a corrected, copy here, so I second the motion. With the corrected copy.
All right. And that would be the individually stapled copy that was provided at the beginning of the meeting. Okay. All right, so it's been, is there a second?
Yes.
That was looking fine.
Okay, moved and properly seconded. All in favor for approval of the minutes of the EC from July 26th, say aye.
Aye.
Any opposed? Any abstentions? Okay. Next, we'll move on to the minutes for the board meeting from July 27th. I have a motion to approve those minutes. Is there a second?
Second.
All right. All in favor?
Aye.
All right. Opposed or abstentions? Moving on. And lastly, the approval of the minutes of the called board meeting from August 9th. And that should be under tab 7 in your binder.
Motion to approve.
I second the motion.
Okay. All in favor?
Aye.
Any opposed or any abstentions? Great. Moving on, we will hear the report from the executive committee meeting that was held this morning. Dr. Joyner is going to give a summary of that report.
Thank you. We meant to consider 4 items, but it ended up being 3 items as the last request did not appear. The first item was a Zoom appearance by Glenn Butt, MD from Picayune, Mississippi. This was a request for an exception to the 2080-hour in-state physician practice requirement for the regulations. Dr. Butt is a recently retired physician who desired to practice in a free clinic 20 or so hours a day. We thought this was reasonable and we granted his request. The second was a Zoom appearance by Melanie Price Bockert from Houston, Texas. This was again a request for exception to the 2080-hour in-state physician practice requirement of the regulation and collaboration with nurse practitioners. After a debate in executive session, this was denied as the request was for a urologist checking labs, which is readily available in every clinic from Memphis to Biloxi. So this request was denied. The third is a Zoom appearance by Theodore Feldman from Miami, Florida. This was requested an exception to the 2080-hour in-state physician practice requirement and collaboration with nurse practitioners. This is a cardiologist who is doing remote monitoring of blood pressure, diabetes, blood sugars, and such. He is associated with Merit Health, so he does have connections here in Mississippi to carry out any further treatment or treatment requests. So the request for an exception was approved, with exemptions limited to the specific partnership collaboration with Merit Health as he presented to the board. And that is the report from the executive committee.
So you have heard the report from the executive committee meeting this morning. Do I have a motion for approval?
So moved.
Is there any discussion? All in favor? Opposed? Any abstentions? Thank you. At this time, we will move on to our committee reports. So we'll start with scope of practice. Dr. Kennard.
Yes. Scope of practice committee did meet. It's called the Order by Zoom a week or so ago. And the topics were,
This is scope of practice.
oh, I'm sorry. We'll get there. This is not scope of practice. Scope of practice does not have a report. I'll probably need
Okay.
to put down this second cup of coffee. I'm a little bit eager today.
All right, so no meeting.
All right.
Okay. How about professionals health program, Dr. Lippincott?
No report.
Telemedicine and interstate licensure compact, the chair is not present with us today. Is there any representative from that committee or anything to report?
I can jump in and say that we did not meet, so I assume there is no report.
All right, fantastic. Licensees, education and communication, Dr. Kennard.
Okay, you ready? All right, so we did meet. We met by Zoom. It was a good
A week or
meeting.
so ago.
A week or so ago. Yeah, you were paying attention. The topics were not unfamiliar to the board. They were very familiar, and no new policies or any such matters were taken up. It was whether or not to and how to, and whether or not we wanted to edit some of the communications to our licensees, which I think is, personally, I think is a very good idea. There's always been a sentiment among licensees in public interaction with them over my career that, well, we didn't know about that, or how did we find out about that? And I think the whole purpose of this committee is to communicate important topics and alerts, which most professional societies do, and that's not what we are. But regarding the 3 topics of the DEA training letter, which is a federal law, as everybody knows, that requires extra CMEs on a one-time basis regarding medication-assisted treatment for opioid use disorder. So, that would simply be reminded that this is a requirement, because it then becomes a requirement under our board rules. The second topic was the guidance regarding semaglutide-based medications. And there were a few edits maybe made, but it was the committee's determination that voted in favor of approving those edits, and those including the IV hydration, which is the third topic. There was minor edits made. All of those edited versions are included in your packet and were emailed to the whole board and every licensee. I'm not aware that there's been any feedback thus far about them, but I'm sure there's right. So that's the fallout is somebody else's deal. The committee, I think, did the job they were commissioned to do by just reminding licensees of these important requirements and communicating with them. And that's it.
Thank you. And I don't know if you want to consider just reiterating or reminding licensees through the newsletter. You might want to remind them of that information as well.
Sure, but well, that's a good point. The last topic addressed was what about the newsletter, and we could double down and mention that in the next newsletter, but we do need to establish the next topic for that letter.
I think there was at least a meeting. So there was a meeting yesterday,
Okay.
just an informal meeting to discuss, communications as well. So
All right.
David was there for that. All right, next we'll move on to the Physician Assistant Advisory Task Force. Again, Dr. Kennard.
There is no report of that committee.
Dr. Kennard, you're doing everything.
Yeah.
And then Dr. Joyner, Rules and Regs.
The Rules and Reg Committee met on Monday, August 28th, 2023 at 10:30 a.m. And we had 2 things to consider. The first being a definition and the second being the Rule 1.6 bariatric medicine weight loss or weight management practice. If you look at the definitions, the only thing changed was prescriptive authority. Means the legal authority of a professional licensed to practice medicine in the state of Mississippi to prescribe, administer, or dispense legend drugs. Licensees holding or possessing certain type of licenses and training such as medical doctors, doctors of osteopathic medicine, are conferred prescriptive authority by virtue of their training and licensure by the board. Any discussion? Hearing none, the other topic we took up was bariatric medicine, and as you can see, we struck the paragraph M, which defines bariatric medicine. And the reason we did this is we got requests from the family physicians of the Mississippi Academy of Family Physicians to consider that all family physicians now treat bariatric patients. And we now have medication that is non-controlled, doesn't require DEA in order for them to treat these patients. And we have a much better outreach to a population that is heavily laden with bariatric patients. So we felt like with these changes in medication, that it was worthy of us striking the requirements for bariatric medicine and returning to family physicians their ability to treat these patients.
So generally are the changes regarding the controlled substance treatment, and the rest was left
But we're not
as a
really,
requirement?
changing the control substance.
Okay, all right.
We're allowing everyone, let's say you're a doctor in Greenwood. Well, you may end up with a ton of patients that might, under these present rules, require you to register as a bariatric physician. But we also now have medication that is not controlled, and you don't have drug seeking and that sort of thing. And so these physicians ought to be able to treat more patients and reach the population freer than they would.
Got it.
That concludes our report.
That concludes my report. And I thank you.
The board needs to take a vote.
Make a motion to approve the changes?
All right, so we have a motion properly seconded to accept the changes for 2640 Rule 1.2 and 2640 Rule 1.6. Any discussion? Hearing none. All in favor? Aye. Any opposed or abstentions? Good luck, man. Okay. Moving on to item 10 on the agenda. We have a approval of a consent order regarding Dr. Peter Clark.
This is a mirror action.
We can hardly hear you. I can hardly hear
May
you.
not be on yet.
It's
Tap it.
it's
Oh.
on, but it's just not loud.
I can either lean over or I can just find inside.
We need your outside voice, not the inside.
Well, I'll use my federal court. Dr. Peter Clark, this is a mirror action from the state of Oregon. Dr. Clark is not here today. Obviously, if the board feels like it needs more information that I can provide, we can schedule this matter for here and have Dr. Clark repeat. Dr. Clark is an ophthalmologist.
Dr. Clark is an ophthalmologist. And his practice in Mississippi, he's licensed in Mississippi, his practice was limited during COVID to, remote reading of retinal images. And, the action in Oregon has no connection with the work that he was performing in Mississippi. He was doing that again remotely, to provide additional care during COVID to Mississippi patients. Now, in his private ophthalmology practice in Oregon, Dr. Clark had a very unfortunate incident. There was confusion over a patient, and he injected the wrong patient. An incident where he performed a procedure injection on the wrong patient. So it was a serious problem, but not connected with the bringing of images in Mississippi. The state of Oregon did discipline Dr. Clark. Originally had proposed reprimanding fairly serious penalties. However, in final and stipulated order, February 7th of this year, so that was the notice where they proposed disciplinary action. Ultimately, Oregon fined Dr. Clark $10,000, required him to take a professionalism and ethics course, prohibited him from delegating authority to sign his own charts to anyone else, and had approximately 6 months in terms of that. The proposed consent order that Dr. Clark agreed to simply requires him to comply with the requirements of the Oregon order. The one difference was that originally we had discussed whether Dr. Clark should be given a reprimand this point. However, this goes to the point that this board does not have the authority to issue them. Oregon did not reprimand Dr. Clark. They gave him a fine. If this board were to issue a reprimand, that would be a new reportable event to the data bank, and would likely start another round of reciprocal things. We did not think that was appropriate. Obviously, the board had. So this is simply, in fact, Dr. Clark does not at this time and has not ever physically practiced in Mississippi. But if he did to come to Mississippi, which he could, Mississippi public have a right to know this incident. So that's why we felt that we need to have something in our records showing that Dr. Clark did have this unfortunate incident in Oregon, and patients to make an informed choice. So I would suggest that the board approve the consent order.
We'll start this with a motion to approve it.
You may.
I will do that.
All right. Bernard?
I'll second.
All right. So it's been moved and properly seconded that we approve the consent order for Dr. Clark. Is there any discussion? Hearing none, all in favor?
Aye.
Aye. Any opposed or abstentions? Thank you. Next, we'll move on to the approval of consent order for Dr. Gregory Hall.
Members of the board may recall that in July, I mentioned the consent order and I talked about Liz Frank injury, and I was wrong. But this is the Liz Frank case that I was thinking of. Dr. Hall is a radiologist licensed in the United States. This is a little unusual because the state that took action and that we are mirroring is the state of Wisconsin. However, none of the activity related to this consent order actually occurred in Wisconsin. The patient was in South Carolina. Dr. Clark at the time was located in North Carolina. and read the image remotely and of a foot injury in which he found no osseous abnormality, only soft tissue injuries to the patient's foot. A month later, an orthopedic surgeon said, well, actually, he's got a risk of a spine fracture. And so the state of Wisconsin reprimanded Dr. Hall, required him to take certain CMEs, include specifically, they required him to take an additional 6 hours of education. It's a radiologist, but a radiological classification of bone and joint injury, including at least 2 hours specific to the Lewis spine injury. And this is a direct reciprocal or mirror action of the Wisconsin requirements. It does include a formal reprimand for Dr. Hall. As you see, the copy of the materials. Dr. Clark signed this on July 31st and signed his agreement, and that was resolved. This case against Dr. Hall. So therefore, I'll answer your questions if I can. Otherwise, I'll be questions.
Any questions? And I'll entertain a motion.
Motion to approve.
Thank you. It's been moved and properly seconded that we approve the consent order for Dr. Gregory Hall. Any discussion?
What it looks like, Dr. Hall is guilty of not being perfect, a perfect human, so. But that was our standard. We'll be a lot busier than you think we are.
2 hours for him to review the.
Yeah, right.
All right, so at this point, we'll take a vote. All in favor of approval? Aye. Any opposed? Any abstentions? Thank you. Next, we will move on to petition for reinstatement of Dr. Massey Headley. So we can read. That's all it says. Yeah. No. That's all it says. Yeah, that's good. Yeah. That we- to go to the issue. Okay. Stop that. Yeah. Please hold on. Please.
Good morning, and I'd like to introduce, most of you know both of these gentlemen to the court, Dr. Matthew Headley and Attorney Tim Simpson. The board, I'll just go brief synopsis, and I'm going to turn it over to Mr. Simpson. This is Dr. Headley's petition. The board will recall that in May this year, Dr. Headley appears for approval of consent order. Dr. Headley, I'm not going to go into the details of the event, but we took full responsibility on the plan and admitted his fault. The outcome of that in the consent order was approved. Board suspended Dr. Headley for 12 months, stayed 6 months, and gave Dr. Headley the opportunity to have 2 additional months from that suspension stay, which could result in a suspension of as little as 4 months. That was to be earned guess is the proper word, by speaking, making two speaking engagements to residents or medical students or colleagues concerning the errors we have made and the lessons that we have learned. As it turned out, it was difficult in the time frame, for it to be meaningful, to send out pretty fast. So it's difficult to get audiences of the size that were originally contemplated for the two speaking events. So Dr. Headley actually ended up doing five speaking engagements to smaller groups. And I know that Mr. Timpson is going to offer materials showing that Dr. Headley has complied with all the requirements of the state, including letters or emails from people associated with all five of the speaking engagements. Telling what a good job Dr. Headley did, how much they appreciated it. I know that there are copies of the presentations and slides, which were pre-approved by Dr. Cleveland. Dr. Headley is prepared to pay his expenses, which the total amount $3,986.06. He's prepared to pay that today. The one procedural issue that I must address is that because of the rescheduling of the meeting, you're actually 2 days short of the 4-month period. 120 days from the May meeting, 4 months suspension, assuming the board approves the additional 2-month stay. That falls on the 16th. So, but if Dr. Headley was not allowed to appear today, the request that his license be restored after 12 a.m. Saturday morning, you have to wait until November. That would negate any possible benefit from all the hard work that you did. So I request the board, waive the 2 days additional days. That the order technically requires them to wait. I may have a few comments after. I don't believe I'm going to have any questions, Dr. Headley. I would ask that you be sworn now in case you need the board to have questions on that. I'll turn it over to Mr. Smith. Yes.
We can.
Good morning. Thank you guys for having us. I'm actually great. You guys want to hear from Dr. Headley, not me. I know. I'll just say, Dr. Headley has gone great lengths to make sure that he's satisfied with the requirements of his consent order. He's done that meaningfully. He didn't do that in ways to check boxes. I'll tell you, I've had a lot of different clients in this setting and others. I don't know that I had one that took the process more seriously and more heartfelt, such as Dr. Headley. I can tell you here, you'll hear from him. He fully understands where he got off track with it. I think he's right. Obviously, Steve is running the years is that'll humble you. And I think you'll hear him say that. And so, okay, I'll just ask him a few questions for the record, and then you guys can ask whatever questions you have. Dr. Headley, you've been sworn in. When we were here in May, correct?
Yes.
Are you all nervous?
Yes.
Okay. That's all right. I just want to walk through your consent order with you. If you tell the board what you've done. One of the things that Paul said that you guys hear me?
Yes.
No. You're right. I'm giving them whichever one's good.
Okay. Dr. Headley, one of the things you were required to do is, as far as to speak at different engagements, we can just kind of briefly tell the board where you spoke, and make that place to be how that process played out with regard to creating slides and actually speaking to it, you know, just tell a little bit about them.
I apologize. Let me just say. We're supposed to do this, and it's still doing it.
Test, test. Test, test. Go ahead, Dr.
I contacted several program directors around the state, the family medicine programs, and started to coordinate the talks and get those all set up. Ocean Springs, Greenville, Jackson, Meridian, and then I spoke out of state at the Academy, Family Practice Academy meeting in Destin. And it went real well. I had a lot of good feedback, a lot of questions. I explained to them my situation. In preparing the slides, I went through a lot of, it took me a lot of time to really go through it carefully, make sure that the slide represented what I wanted to convey. Also utilize some of the information that I learned in the pro course, as was suggested here. And I think that was real helpful as well.
And did you, and I believe, board members, you have in your packet letters or emails from the different program directors. One is evidence that he had these public there, but two, that it was something really meaningful experience for them. Did you get some, one of the things you were required to do is have the office here approve your slides and the content of it. Did you do that?
Yeah, I did. I'm going to make some changes.
Okay. Another requirement is that you and your wife divest yourselves of all interest of the hydrotherapy clinic for private therapy clinic for. Have you done that?
Yes.
Okay. And have you provided the board and the packet they have with proof of that?
Yes.
All right. Dr. Edwin, you mentioned a minute ago, you were required to do a CME pro course. Did you complete that?
I did.
Okay. And did you provide us in the board with a copy of the certificate of completion? Okay. Now, I don't think we have a document for this because it's not possible, but you also committed to the board that you would never again practice in the area of hydrotherapy. You're under oath here today. I want you to tell the board or you need to keep that promise. And as Paul mentioned, you're prepared to, I think you have checked with you today for the full cost of the board's investigation.
Yes.
Okay, and to your knowledge, have you obeyed all other federal, state, and local laws in the last 4 months? Okay. I think that completes your requirements. And what I want the board to hear from you though directly, in your own words, just tell the board what you've learned through this process.
I've learned the importance of understanding the regulations, knowing them, adhering to them, understanding how important it is to, with regard to supervision of mid-level providers, knowing everything that you're supposed to do and making sure that you do your due diligence on all your responsibilities, also the importance. If you have any questions, contact the board in a proactive manner where you don't get yourself into that spot. And lastly, you never sign any documents unless you fully read them and understand what you're saying.
As the preparation for the speaking event and just standing in front of peers and telling your story, has that been helpful to you and learning experience for you?
Oh, yes, certainly. And it reminds me of how you have to really stay on top of what's going on with the regulations because they change. You need to stay abreast of that. And it was a humbling experience. And it made me very aware of how serious your obligations are in your supervisor.
The last question I have for you is kind of like you have. I asked one of my kids, are you sorry for what you said?
Yes, sir. I'll never forget this. It's one of the worst things that ever happened in my life. And I understand the gravity of it. I love practicing medicine. It's just It's now careful without the King the Cavaliers.
They never trust a lawyer when I said that we're gonna have to go out what, I don't know what. If you feel like you've done to the best of your ability, you satisfied with the requirements that you can in order so that you can go back and back. That's all I have for my regular.
Just to be confident, that's it. I really appreciate your honesty.
No,
Both of them.
Speak up. Okay, so anyway, I was there.
There you go.
Talk to David Best, association. I appreciate your honesty and candor with that, and I really appreciate the way you feel with the questions that our members questions you. And I think our members of the board need to know that it really has gone out of his way to provide everything that consent to the. So I really do, I appreciate all that. Thank you.
Any other questions or comments from the group? Paul, do you have anything else?
I have no questions, but we've got this short. I have a short statement I'd like to make. I don't have any questions about the cases. I just wanted to say that, board tried something about the veterans. Speaking engagements, giving them the opportunity to earn back, some of the suspension months by doing a public service, by going to speak to the colleagues and the students. And I think as everyone said, Dr. Logan said, it was obvious that he took this obligation seriously. He worked very hard to do exactly what the board asked of him. And I believe he has shown that when handled properly and with the effort that must be put into it, this can be a valuable tool. And especially in light of the limited options that we will have. With regards to this. Everything I have seen reflects that Dr. Eddie has fully performed the obligations of the consent order. And again, I would just ask technically if the board grants a statement that it be made effective on Saturday, September 16th.
So just in follow-up, just as a matter of process, there have been, so we've heard from Dr. Loper, but there were references made to other items that might have been or could have been considered as exhibits that we actually did not have. And just for the sake of the board members, I would like for them to have an opportunity at least to review whether it's the statements from individuals who were present or what have you, just so that we can consider everything completely. So
I apologize. They were not in the board book, but there's a link on the service product to the desktop.
thanks, that's all I need.
And in find where I have plans to help. So, but all of the exhibits are there.
So there's actually, guys, there's a exhibits folder that's listed, so we don't even have to click into the view. Thank you for that.
I apologize. We are trying to modernize. There's some difference.
We're paperless-ish.
Dr. You'll see in the package, the first 40 some odd pages.
Are the slides. Mhm. No, thank you. I just wanted us to be able to consider everything that had been mentioned.
Oh, these slides.
Paul, has there actually been a petition filed for reinstatements? So how do we get around 73-25-32 that delves into the particulars of a petition or what should accompany a petition for reinstatement?
I believe the medical requirements, the, requirement that the recommendation letters to colleagues, I believe the statements from the people who proposed, those organizations would serve, for that. I'll have to pull the statute out to run down to this, but I believe that all is required.
It's 2 recommendations for physicians or osteopaths licensed by the board, and 2 or more recommendations from citizens, each having personal knowledge of the activities of the petitioner.
Not all of this.
So we got-
What Mr. Simpson has said is that if the board, would make this ruling contingent on providing that information to us, those letters, before Saturday, that we would sure get it, and we can have that sent out to the board. Actually, physically, the letters.
What was that? What section is that in?
It is Mississippi Code 73-25-32, subparts 1 and 2. I have it right here if you all want it.
Oh, yes.
Yeah, but I believe I got some caught up in the fact that this was something unusual, sensitive. Yeah, I mean, you're. The need for the period of time is not really powerful.
Can we stipulate that as long as we have those prior to being reinstated in my possession, that the reinstatement will go on through?
Yes, sir. I believe that if the board agrees that, assuming the requirements of the statute are met, that they can go ahead now and do the vote, and you can review for compliance.
Can you repeat, someone please repeat the actual statute for me?
73-25-32.
Okay. And we entertain a motion that we approve it based on that contingency. I told you, I finished that after a half cup of coffee. I mean, it's,
All right. I just wanted to make sure we got all this right there. So is there anything further, gentlemen? Okay.
No.
All right. With Dr. Kennard's urging, I will entertain a motion at this time. What is it?
reinstatement granted. All right, so this is where, should we just do it effective immediately because we're about to approve it on the contingency? Or what was your wording
We
about the
have to go
timing?
to-
It's to go to 2 days out.
We gotta give it 2 days.
Okay,
Right, the contingency will have to be upon receipt of the petition with the supporting letters to comply with the statutes.
Okay.
And if that's done by Saturday, then it's all good.
so here's the motion. Reinstatement granted effective 12 a.m. 9/16/23, contingent upon full completion of the statute requirements regarding letters of support found in 73-25-32. via report to the executive director of the board, Dr. Cleveland.
So, so I have a motion. Is there a second?
Loper seconded. Well,
I thought,
we-
no, he actually made it.
all right, gotcha.
So I need a second. Don't everybody second at once.
Second,
All right,
All
got it.
right. It's been moved and properly seconded. Any further discussion on this matter? All right. All in favor?
Aye.
Aye. All opposed? Any abstentions? All right. Dr. Headley, thank you so much.
Thank you.
At this time, we will continue on with the agenda. Item 13, the case of Dr. Sutter from Vicksburg.
Yes, ma'am. This case has been repeated several times. I am requesting that you join the request of his counsel. Actually, items 13 and 14 go at the end of the country. Each of those are complex cases, and we've had scheduling issues with regards to out-of-state expert witnesses, et cetera. But again, honestly, I believe on the board that for Dr. Sutter, the interest of providing you with the process and the opportunities to defend himself. I believe that continuing to warrant Mr. Rasheed, Doug Rasheed, his attorney, is going to be here later this afternoon, and has several other matters on the agenda. He and I have discussed the fact that both Dr. Sutter and Dr. Factory, complex hearings that we typically schedule Dr. Sutter for the November board meeting. And we typically schedule Dr. Factory January board meeting. I believe we try to do more than one of those. We need to regularly schedule meetings. So I would request that the board continue Dr. Sutter's matter to the November meeting and request that we continue Dr. Reed's case until the end of the week.
All right, so we'll take item 13 first. Is there a motion?
So moved.
second, a second.
All right, any discussion? All in favor? Aye. All opposed, any abstentions? Okay, and for item 14, is there a motion? Move for continuance. Is there a second?
Second.
Okay. Any discussion? All in favor?
Aye.
Any opposed? Or abstentions? Thank you. Moving on to item 15, Dr. Holzhauer.
This is just some. We did have a reserve time for the Navy meeting. That whole tower was held. But the attorney requested. We have a second continuance for that.
This time I'll entertain a motion.
Second. Second.
Any discussion? All in favor?
Aye.
Opposed? And abstentions? Thank you. And the next item is Dr. Michael Sanders.
I'm gonna go back to something that I've already said, it's not being focused all the time. I'm trying to hang my head on. All right. The affidavit against Dr. Sanders, the charging affidavit must be, and the statute requires you to amend charging affidavit. That just defendant's license must be given a minimum of 30 days notice, which made this decision about 2.5 weeks ago. And also, there was no way we could, have Dr. Sanders here today. I do think that the charges will be changed from the, and at that point, Dr. Sanders will, you know, and himself forward. So I'm glad to continue with November. We will see how many of these we can do.
Is there a motion?
So moved.
So,
Any discussion? All right, all in favor? Aye. And opposed or abstentions? Next item.
At this time, the next three items. Mr. Peter and his clients are going to be present at 1 o'clock. We expected a little bit longer than what he said. So it has the board to take a slightly early lunch break to turn at 1 o'clock here. And at that time, number 19 refused to be, which probably the first doctors, but the rest of the has decided that hearing is unnecessary. He has agreed that it's that the temporary orders should stay in effect. Until the world can resolve, nothing like that, United States, so that's a quick matter. Dr. Hussein has decided, as I understand, again, this material is late this afternoon, she did, that she violated the rules and put on a concentrate her case on what the appropriate penalty might be. So that one would probably be interesting in a second. Dr. Florida, of those three matters, that's the only one that's going to be a full hearing. And again, I do not anticipate it to be off. And so if we went to rescue, then Dr. Hussein, they got the Florida, that would resolve three of which two cases that was in the same position. Very positive. Item 20, case of Gregory Ozan. So funding house, some of like no, it's like announced it's wrong. It has to be different. Dr. Ozan, his attorneys, originally Dr. Sanders, Dr. Ozan and his attorneys and his out of state witness not be present by in the morning. So that hearing cannot begin until the morning. We anticipate the attorneys are going, they anticipate their case will take approximately 2 hours to present. I would think my case would take an hour or less, but that's my point. So I do think that hearing will take place in the morning. And so I would request the board adjust the agenda so that after lunch break, we would do item 19, then 18, 17, and then 20 we would go. And I've made an experience last this one.
All right. Do we need a motion to amend our agenda, or can we just do it?
I usually suggest a motion to amend and approve.
So I need a motion to amend the agenda as stated, which would be to move basically 19, 18, and 17 in reverse order. So that would be DeBrescu, Hussein, and then Torgova. So is there a motion to amend the agenda?
So moved.
Okay. All in favor? That sounded unanimous, so we're gonna go with it. And also, I guess at this point, I will entertain a motion for us to recess for lunch to resume our agenda at 1 p.m. at the time which the licensees and their legal counsel will be present. Is there a second?
Second.
All in favor? All right, we're recessed. Be back at 1. We'll continue with our agenda, the amended agenda. So we are starting now with the matter of, let's see. Dr. Dabreski.
Oh, see that. It is. Thank you, proceed. This is a matter that that's been here representing and it's going to also have to be done. Dr. Rescue is the surgeon. There was a complication, serious adverse event, and surgery in Alaska. Alaska, there's some expense we got to the rest of his life. Several of its veterans followed suit, including Mississippi. Dr. Cleveland, shortly before the last meeting, issued a temporary suspension without hearing, in accordance with the statute that requires to provide a hearing post deprivation hearing within 15 days. The hearing was set and Dr. Rescue summoned to be beyond me. Dr. Rescue contacted me directly, and I had counsel at the time and asked for a continuance, which I agreed was ratified into law. He now has retained this here as his attorney. Just a couple of days ago, we were able to reach terms on this matter. And what this procedure and Dr. Rescue agreed to is that with the approval of the board, that the order of temporary suspension entered by Dr. Cleveland on I believe last maybe out by 2023 should remain in full force and effect until the underlying proceedings in Alaska are completed. And this board has not had that. There's been no hearing in Alaska. There's been no investigation of the completed, so there is no final outcome. There's already particular experience. And yes, we agreed to stay.
Microphone.
Oh, stop. Good afternoon. Yes, we agreed to, Dr. Rescue agreed to the stay of the proceeding and the temporary order of suspension remains in effect until this board is able to resolve the issues which should follow after their hearing on the suspension itself. The temporary suspension should say that in Alaska. Like what happened is there was some suspension in Alaska, but there's never been a hearing that we were going to do here today. This board, following that temporary matter, the subject suspension is gone, and then there's been nothing to the merits at all. Even the few states that have followed suit, there was some suspension or temporary suspension. They have not entered a suspension, and there's been no other hearing, and we've been followed. There's been no hearing of the merits at all anyway. So everybody's kind of waiting on Alaska to go ahead and take their hearing suspension. Or have any questions?
Where does Dr. Babisky practice?
He practices in multiple states. I believe this is in Alaska. He's also licensed, I believe, in awesome about Illinois. No, we have that. Right.
If you look in the summary, yeah,
Illinois,
we have Illinois, Alabama, Louisiana, and Alaska.
That's probably the 33rd job.
All right. If there are no further questions, is there a motion?
Second.
To provide a continuance, okay, any discussion? All in favor? Aye. And opposed? Any abstentions? All right, so the continuance is granted.
So the motion is approved for continuance.
If you can have just a moment, take care of a couple of housekeeping things. I think we can do it. Would you like me to read the pages for the full quarter?
I am more than happy to do it. Just apologize, not familiar with y'all's process, but could we let the record reflect that counsel for the board and for the respondent have presented and exchanged their exhibits for this matter? And there is no objection to the introduction into evidence of the board's exhibits marked MFB 1 through 7, 16 through 22, 24 through 61. So those will be entered into the record. And conversely, the respondent has provided her exhibits, and with no objection, we will introduce into the record Hussein exhibits 1 through 18 at this time. Yes, sir. Yes, please.
Please.
Dr. Hussein, if I understand correctly, business violations of regulations. As you can see in the affidavit, which is begins on MSP 4. The charges relate solely to violations of regulations concerning collaboration with mid-levels. And the violations are violations of the 80-20 hour rule and the 75-mile rule. Dr. Hussein is not located in Mississippi, but she collaborated with a nurse practitioner at a Columbus, Mississippi area pregnancy clinic for approximately 5 months from November or December of 2021 through approximately April of 2022. Dr. Hussein admitted his case was investigated by Brett Evans. State board members have seen him, although Brett's never testified, maybe his chance in the series of calling today. But Brett investigated this. Dr. Hussein was a very professional and cooperative in this aspect. I want to make that clear. But what was also clear, and Dr. Hussein admitted in a number of exhibits that, in fact, she had violated the rules concerning collaboration. And so that is really not an issue with that. And that issue is established. I don't think they're going to dispute that she is, in fact, liable in the sense that she has committed violations. It is my understanding that their case is going to be based primarily on what level of discipline would be appropriate about what you're saying. We obviously believe that these are serious problems, especially with the rapid expansion of telemedicine and large state companies conducting telemedicine activities in multiple states. It's more and more important that physicians understand the laws and regulations of each state in which they operate, in which they practice. And it is an obligation of the physicians to find out what the rules are, what the laws are for their practice, and not after. Every board meeting for the last several years, the executive committee has considered one or more requests for waivers or exemptions for the 80-20 rules, often to the 75-mile rule, these board meetings. That was not done. Actually, same practice, 5 months, collaborating with the nurse practitioner, and never received an exemption. That's really all I have to say.
Yes.
Directly states that Dr. Hussein does not deny liability under statute if the board decides to impose discipline. That's not the reason that she was asked for this hearing. She was asked for this hearing to be able to explain the circumstances in which this influenced their votes. Dr. Hussein has not intentionally ignored this board's rules, violated them. She relied on an agency that pairs physicians with nurse practitioners in collaboration all across the country. Mississippi's rules were different, apparently, that agency was accustomed to. That's not an excuse for physicians not looking behind what the agency is doing. But we all busy, we all employ people help us and doing things on scale. And there was no basic harm no patient issue whatsoever. It was simply a matter of not submitting the required documentation and filing that. We'd like to be able to demonstrate to you that she has a stellar background. She has never been disciplined in any other state. She has never had a complaint from that board. She's never had privileges denied in that way. How about you saying? That's, I'm saying, if I understand the exhibits and you currently hold active licenses in 51 states.
All 50 states and UC, correct?
That puts quite a burden on you.
Yes.
Because you only have to deal with the law that they just one state. They're dealing with different laws and legislation.
Correct.
You have a lawyer, the council, an agency that is supposed to educate you and work with you around compliance.
Yes,
Does that work in this case?
unfortunately, I don't think so.
Is this an agency that you contain yourself, or is this the company that you work?
I retain myself.
Do understand that we're responsible for drawing up the license and compliance with the law.
Absolutely, yes.
Where are you physically located?
I am American.
And how many states at this time the license is speaking? Is your practice in state and telemedicine?
Right now it is, correct.
How many states are you actively practicing telemedicine?
Every single,
Okay. What company do you work for? Work for a company that like refers patients to you and then to the patients? How is that?
right, so right now my primary work is with Walmart Health and Tiny Care. And they're both my nationwide telemedicine platform.
So how does a patient get to you?
Well, I guess they would log on to so for example, Walmart Health, it's a service that's offered for Walmart employees. And with Tiny Care, it's a service that's offered to university students and college students across the country.
Do you know how the system routes patients, determines which practitioners must not be?
Well, for example, with Tiny Care, I'm an internist, I'm the only provider, so if someone calls in the middle of the night, I'm the only one who's working there. And with Walmart Care, I'm not sure how they route the patients, but they generally give an even more sought after rare licenses that maybe other providers don't have.
And so when you have, what information do you get about the patient?
Not very much. So just the way, a patient comes into the office, we'll have some basic, background history, past medical history, if they've uploaded vitals. So pretty much the same information we get in an office visit, maybe a little bit less because patients don't always give us the information that we need.
So, what sort of an audio platform do you use for the access to things?
It's usually on the computer.
So you take the history years of visit?
Yes.
Okay. So you don't use questionnaires or forms for the patient to get out and then.
So for both platforms that I'm working on right now, I don't think that's there, but I'm not really sure what the patients necessarily see.
The collaboration with nurse practitioners at the clinical slide in Columbus, that wasn't associated.
No, that's something different.
Okay, so how did you first become involved with collaborating with a nurse practitioner?
Well, I was, actually, somebody reached out to me because they knew I had this new licenses. And they asked me if I'd be interested in helping, this was during the end of towards the end of the COVID pandemic. And there was, at the time, a real need for any healthcare provider to really provide services for the community. And they did ask me if I was interested in helping. And it wasn't just, she happened to be, in Mississippi, but there were a couple of other people as well.
Did you begin collaborating with nurse practitioners in addition to the nurse practitioners?
Correct, I had a few. So at the time, I had about 5.
How many different things?
At the time, it was about 4.
And you still collaborate with those?
Not those particular ones. I've since then left that company.
Collaborating, firmly collaborating with others through the other.
I do, yes.
How many do you find collaborate with?
About 20.
Yes. Are those APRNs or physician assistants or combinations?
A combination, and they're not, most of them are part-time.
What type of practice area collaborating with you?
Primarily family practice.
And so you consider the collaboration therapy to be part of family practice?
So it's not necessarily part of family practice, but the nurse practitioner is also doing urgent care and primary care.
So this wasn't exclusively collaboration.
But I will also say that, IV hydration wouldn't be considered outside of family practice is what I'd say. It's a more unusual.
So the name of the business was Resilient, REDILIENT, Hydration Lab.
Correct.
What was the name of the nurse practitioner that you graduated with?
Erica Horton.
Know about the manner in which there's building conducted for the practice. That's the building.
In what way?
Well, let's start with personnel. Other than this nurse practitioner, who else worked?
That's not in the scope of, what I would be working with her for. I just primarily work with her in the medical, like looking at the records and making sure she didn't have any medical questions. I did not supervise her practice.
So, are you aware of the little first see the complaint against you?
Yeah.
This is not shared with the nurse. I wouldn't afford the plan. Probably complaint with the virus. I'll read it. Are you aware that nursing board provides information the basis for a complaint and recommends it start an investigation concerning the practice?
I'm not sure who told me, but it did come to my input. I did find out that there was some complaint against this.
This is on page MSB page 17. That the number hard copy, I understand you not continue to speak up. I'm sorry. I'm reading bottom of page 17. The board was contacted by the Mississippi Board of Nurses, the director of advanced practice in High Point regarding the license city. The High Point stated to perform the site visit on APON Erica Horton in the location of the Columbus Farm Resilient Play Foundation. The door was locked to the location, however, the sheriff stated that the major care clinic exception provided the menu for Dr. Patrick for review. Dr. Patrick is notified by APON to the office, where he said she was able to conduct the site visit. Documentation is described as follows: the no production of QA or QI. The APRN was able to quote the protocol, but she was unable to print a copy for Dr. Patrick at that. We discovered IV fluids are administered through no LOCA or HMP. That Director Hopkins wished to provide this information as it relates to us. So if you ever aware that with the APRN, why would not be hydration therapy with no LOCA?
Well, that's incorrect. So there definitely was a workup, there definitely was a physical. We did ask for laboratory studies, we did have a protocol. I think in those circumstances, what I understand is the investigation came up when the nurse practitioner was working at a different job. So she was asked to produce the documentation, but she wasn't at her job, she was at a different job. So she wasn't able to produce the documentation at that time. From what I understand, everything was provided later on, everything was in it.
So later the charge was provided, like the workup and.
Absolutely, yes, correct.
Now, in the record that the council has provided copies of, there are some pages that appear to be pertaining to chart. Is that correct?
Yes,
Use of chart was used related to Ms. Ford.
correct.
Okay. And now, I just want to show you these, I'll speak of. So that's page 14. Right, you see the 21, correct? He's saying 15, that's the January 22. He's saying 16, it's for February 2022. He's saying 17 says collaboration with minutes. Now this is different. What is this? Is this a?
No, so all of these were actually, so this is a form that I developed at Brown March. So that we can just document the meeting, but a meeting was conducted every single meeting. We just didn't have a phone.
So before March of 2022, you just have a list of the patient names.
Correct, but the same, collaboration meeting is going during those months.
But there's no documentation of what was discussed in the meeting, the issues that you discussed with Baker and
Well, there's documentation somewhere, but you don't have it.
you haven't provided.
I don't see it. I don't know.
Where would that documentation be?
I can find it.
Already at the hearing, I just thought that you haven't produced any to exam. This is what you think. Saying. What do you think the board should do? 5 months, 5 months.
Well, I sincerely apologize. It was definitely not intentional. I have not had any problems with my license. I've never had any practice suit. I work with, very good intentions. So I am very sorry that this happened. I did rely on people to help me. And they, you know, missed the regulations, and I did check them myself. But in most places, the regulations are in the nursing board, not from the medical board. So Mississippi has it in a bit of a different place. So I did try to, this. So I'm at your mercy. I really hope that I don't get a public record that will affect all of the licenses, all 50 of the licenses.
Maybe you start employing an agent to assist you in time with regulations that frequently says.
From the very beginning, from, after my first license with Maryland for many years. And then after that, as I started to have other licenses, I've always had somebody helping me to supervise and make sure that I'm in compliance.
And what was the name of the company that first helped you and take your employees to the next?
Doctors or providers.
And it's my understanding, start that. You've expressed in at least one email I gave or letters that you are investigating is in the documentation that you believe the reason for the reason you started connected to you is because of your background in operation therapy and that her practice is about that.
Yes. Yeah.
Heard you apologize for violations, and I heard you say that you posted the bill and not be a public reprimand. But my question is a little more specific. And do you have any suggestions for this board, recommendations that you think would be appropriate for violations?
Well, if I had my choice and if, I have always wanted to help underserved, the underserved community. If I have to do something, may I have some public service or something where I could actually be helpful to Mississippi? Otherwise, I will have to do a tremendous amount of work. And I'm not sure how helpful it is other than, making me feel already more bad than I already feel right now.
I reserve my question for our patients.
Okay. So you may step down until called at a later time. Paul, do you have another witness?
Having put my exhibits into the records and after the same testimony, I have no, nothing more in my case.
So do you rest? Mr. Mercier? Sorry. Mercier, sorry. All right.
To respond to how John involved in investigating.
Okay. You would please. We need to get you sworn in, so. If you would stand and face the prayer order. And Mr. Mercier, we're going to ask that you speak up just a little bit.
Okay, my fault.
That's okay. Thank you.
Mr. Dawkins, I'd like to direct your attention to what is base number MSB 16. So, could you explain what that is? This is a
This is a complaint form that's filled out by me based off of, well, it's our internal complaint system. So when we get information from another agency, or this is also what the public would see as well, how they fill out complaints. We use the same system. It's a complaint that I put in based off the information provided by Ms. Highfield with the board of nurses.
This is what initiated the complaint procedure against Dr. Hussein.
Yes, sir.
What information did you have available whenever you completed this complaint? Should say,
Sure. This was based off of a phone conversation, I believe, where Director Highfield contacted me and relayed this information to me.
If you look on the next page, MSB 17, there's a narrative there that Mr. Barnes is reading from. Is that the information that she provided you?
Yes, sir.
Is there any other information that she provided you other than that?
Not to my knowledge.
You will agree with me that that narrative doesn't address any care provided by Dr. Hussein to the patient.
No, sir, not directly.
If you look up above that narrative under incident information, would you read what it says under incident type for the record, please?
Yes, sir. Unprofessional conduct, substandard care, unprofessional conduct, practicing outside the scope of legitimate professional practice, unprofessional conduct, mid-level collaboration violation.
If you just said that you weren't provided any information regarding any care that Dr. Hussein provided to any patient, correct?
Not directly, yes, sir.
So you agree that she did not provide substandard care to any patient?
Next. Seems like.
That's the whole point.
I'll let him answer. Overruled.
Sure. So may I explain? Okay, thank you. So the information she provided, the statement, second line from the bottom, it was discovered, excuse me, that IV fluids are administered with no workup and for H&P. That was the basis for that incident type about the substandard care portion. So the purpose for these incident types is so we can kind of keep track of what these types of cases are. It isn't necessarily the be all end all. And this is definitely an issue. This is simply a categorization of what type of matter this may be.
I understand, but Dr. Hussein here is defending her license, and you have made a statement here of substandard care. I'm simply trying to clear the record that we're here about a paper documentation submission is not care that Dr. Hussein provided to you.
Yes,
If you don't have any evidence that you provided substandard care to a patient.
I do not.
Yes, sir.
Okay.
Okay.
The respondent would like you to use as new exhibit, the final order of the Mississippi Board of Nursing for Erica Horton, which was executed on March the 26th, 2023.
With no objection noted, we'll introduce that into the record as, what exhibit is that?
I think it's going to be.
Hussein 19?
I can't.
Please.
Mr. Dalton, you had a chance to review that final order there before.
I have it in front of me, but I haven't read all of it. Yes, sir. Go ahead.
All right, well, let's just kind of start from the beginning. We agree that it's, the Mississippi Board of Nursing versus Erica Ford.
Yes, sir.
And if you look on the third page, we'll just go through it this way. And look under paragraph number 10, under penalties.
Yes,
What does it say is the penalty for this Fulton here? In general, read them all.
sure. So A states formal reprimand. Respondent agrees to accept this formal reprimand, which will become a permanent part of respondent's nursing record. I'm sorry. Respondent agrees to accept this formal reprimand, which will become a permanent part of respondent's nursing record.
And you see there that the discipline is a formal reprimand, a fine, 3 classes in nurse orientation.
Yes, sir.
Okay. Now, let's look at what it says the incident was that brought this about in paragraph 9. Would you read that for the record?
Yes, sir. I'll read this one. Specifically, on or about April 18, 2022, a site visit was performed by the board at Resilient Hope Hydration Lounge, the respondent's listed practice site. Records from the Mississippi Secretary of State's office indicate that Resilient Hope Hydration Lounge was formed on or about February 1, 2021. Resilient Hope Hydration Lounge was not approved as a practice site by the board until on or about February 2nd, 2022. Patient records dated January 7, 2022 revealed that patients were seen for treatment at Resilient Hope Hydration Lounge prior to approval by the board as required in Mississippi Admin Code, Part 2840, Rule 1.2 D2. In respondent's statement dated April 18, 2022, respondent stated that there were no medical records on patients to support a diagnosis for IV hydration, and the respondent did not have a signed QA/QI plans as required by Mississippi Admin Code, Part 2840, Rule 1.4. Respondent has since produced both medical records and signed QA/QI plans.
All right, let's start with that last sentence. Would you agree, looking back up, you're familiar with orders because you did a record investigation. I didn't even do it correctly. What is your position here?
I'm the Director of Investigations for Medical.
Okay, so you're familiar with board orders.
Yes, sir.
And you'll agree what it's saying there is that the respondent, Erica Horton, in that case, has provided the medical record that saw, as well as the QA/QI plans.
That's correct.
I'll allow it.
You heard the testimony of Dr. Hussein earlier in question to Mr. Barnes when he asked her about the medical records. You remember that?
Yes.
So you agree with me that what Dr. Hussein testified to was that subsequently the medical records were provided to the director of advanced practice of nursing board. It's consistent with what it says in the order.
That's what it seems to say to me. Yes, sir.
And as far as what the nursing board was disciplining nurse practitioner important for, it's for a not having an approved site location prior to beginning practice. It's not for a patient safety issue, correct?
I'll sustain the objection.
Would you agree with me that what they're saying in this board order in paragraph 9 is that it was a site, excuse me, it was a site approval issue for which she was being recommended.
Yeah, Mr. Mercier, I think we can all agree that the order says what the order says.
Okay.
If we could just move on from that.
Trying to correct her.
I understand.
Are you familiar with the regulations and statutes that govern positions in Mississippi?
Generally, yes, sir.
That's your job as the record investigation manager.
Yes, sir.
Can you tell me which regulation or statute requires a collaborating position to maintain minutes of meetings with a collaborating perspective?
For the admin code, so Mississippi Administrative Code Title 30, Part 2630, collaboration with nurse practitioners references that you must maintain, in addition to your chart review, you must do quarterly review, and those must be documented. I think it's the language it uses.
But it doesn't use the language minutes, so.
It doesn't say that. It says document, I believe, without having it in front of it.
Thank you, Ralph. No more questions.
Cross?
So could you quickly turn back to NFB 7 complaint form,
Yes, sir.
marriages? Comparing that to paragraph 9 of the nursing code, which you have about. Look in the last sentence, respondent has since produced both medical records and signed PA. Is there anything in that paragraph 9 which is inconsistent with the narrative that is contained on page 317?
No, sir.
Now, this is not a chart.
No, sir.
This is an initial report. Well, so is that what a complaint? What is the purpose of a complaint? What is it?
Yes, we receive information, as I was told, Mr. Mercier, and the purpose is we take the information and is evaluated by Dr. Cleveland as our process. And if it's determined that there may potentially be a violation of regulations, we would then initiate an investigation to determine whether the complaint holds merit or not.
Based on the information provided to you at this time, did you know who is necessarily responsible for the alleged substandard case?
No, only that our licensee was somehow involved with this practice and needed to be investigated further.
Mr. Dalton, under the regulations of this board, if an investigator meets a licensee, does the investigator have the right to presently see on the spot medical records and other documentation from the complaint?
Yes, absolutely.
If you're looking at again, at the nursing board order, according to this order, when the site visit was made, respondent told them there were no medical records to support the diagnosis of evaluation, and that she, the respondent, that is the nurse or the RN, did not have any signed PA outcomes as required by their administration. All right.
That's correct.
So the penalty, the nursing board imposed a criminal reprimand,
Yes,
and fee, $500 fine.
yes, correct,
A legal aspect of nursing board,
correct.
everyday ethics, guiding nursing practice for
Yes,
documentation for
yes,
advanced practice registered nurse orientation.
correct.
Dr. Hussein ever charged by this board as providing substance abuse?
No, sir.
To your knowledge of the charges against Dr. Hussein based on the violation of the 80-20 mileage, 80-20 hour rule and the 75 mile.
That is my understanding.
But any other charges?
That's my knowledge.
Any redirect? Can we release this witness? You may step down. Your next witness,
Oh, Dr. Hussein, did that pop?
Dr. Hussein, if you could take the stand, you've already been sworn in.
Hussein, you have both sets of the board of business and your.
Yes.
If you were asked a question a little while ago about Mr. Barnes, we know part of the story, but I don't think it's going the full story, so we're not going to try to belabor this, we're going to go through it, so we can try to put things back before the board. I had mentioned in opening about your history as a physician, just in general, where are you, and where do you practice, what practice location, I should say?
I think so. I'm physically located in Maryland. And right now I primarily do telemedicine for Walmart Care and Primary Care.
Now, I had mentioned that you never had a complaint to a medical board or one by a facility or eternity. I didn't mention malpractice claim. You ever had a malpractice?
Yeah.
But why are you practicing telemedicine?
Oh, well, I was in a regular urgent care practice up until, October. Unfortunately, I worked through the pandemic, but towards the end of the pandemic, I did get a severe case of COVID. And it's affected by respiratory system, so now I have, some physical limitations.
Are you saying that, because of the physical limitations, it's easier to practice telemedicine?
Yeah, I don't think I could go back to a physical, job as a doctor anymore. Yeah, so right now I primarily can do, review work and telemedicine work.
Looking at, your exhibits, starting with the same one there. in front of you. You're currently licensed in all 50 states plus the district. How long did it take you to acquire a data?
So a very long time. I started this during the COVID pandemic. So I started about maybe about 2 or 3 years. About 3 years. Now.
And I think you testified earlier that your primary practice is family medicine.
Yeah.
But there was some discussion about IV hydration. What experience do you have with IV hydration?
I had extensive experience. It was very popular when I first started practicing medicine 23 years ago. It was sought after by a lot of patients, and I did some research, on IV hydration back, during that time. But then it sort of phased out, like it wasn't as popular anymore. But during the COVID pandemic, I researched, and I had a job with Same Day Health, which was a company that specialized in COVID testing and, COVID treatments. And, they asked me to supervise their program. And I was working for them, and I had that experience as well, working for this company, and they were nationwide.
The nationwide company, what was the name of it?
Same Day Health.
Looking at your CV under the education, it looks like you went to George Mason University and Howard University. You from the DC area?
Right.
If you would, let's just briefly go through your professional experience. I mean, you've got on here a number of ones, but let's start with medical review Institute of America. If you say April 2020 to present, what is it that you do for them?
I don't work for them as much, do as much work for them anymore, but I would review, difficult cases, insurance denials. So if you had a patient that had, a cancer case and they were asking for a more unusual chemotherapy, and if it was getting an insurance denial, I would review that and see if there was any medical necessity or if there was any basis on approving that claim.
There's several others listed below that, which seem to all revolve around collaboration with mid-level and or telemedicine. Correct. What most of those are.
Correct.
And that goes back to about what time period in your professional career?
I would say about 10 years, last 10 years. But the collaboration is very new, so that didn't start till October of 2020.
In these 51 jurisdictions, you practice telemedicine
Correct,
in all 51.
correct.
What about Mississippi currently?
A lot of patients in Mississippi. Yeah.
About how many, what about that? Do you see any office visit patients in your practice?
Not anymore.
It's 100% telemedicine.
Correct.
How many patients daily do you assess, provide medical service for with telemedicine?
I would say a minimum of 20. As we approach the winter season, it'll probably double.
How many states normally are covered on a daily basis?
At least half,
So you, 25 states.
at least, yeah.
And so in a month, you probably covered the whole nation.
Yes.
There's a mention of physician reviewer under CV. Let me see if I can find where it is. There it is, up on the top of Hussein 3. It says perform independent physician peer review for clients, including the Maryland Board of Physicians, to determine if cases met standard quality of care for treatment and appropriate documentation in accordance with Maryland law. Adverse determinations require testifying and engaging in consultation with the Attorney General's office and occasionally expert witness testimony. Can you explain that a little better, what you did?
Yeah, so it's basically kind of what we're doing here and making sure that, my peers were upholding the standards of medicine. And if they weren't, I helped them, determining what would be the next step.
So you were engaged as a physician by the Maryland Board of Medicine?
So the Maryland board contracts a lot of their cases out, so they don't specifically hear each case. So I would take some of those contracted cases there.
And what would be your duty once you received a contracted case?
I would basically review the case just like this and make my determination. And, figure out what violations might have occurred.
How long did you do that?
5 years,
How many cases would you say that you reviewed for the Maryland Board of Medicine?
maybe about 20.
Mr. Barnes asked you earlier what you would have the board do as far as imposition of any discipline. He didn't ask you first if you thought the board is required to impose discipline. And based upon situations you've seen with the Maryland board, did the Maryland board always impose discipline when there was a violation of any of the regulations?
Not always. Not always.
Gonna overrule since she's answered, so we'll move on.
I didn't hear her answer.
Oh,
Not always.
It's a wash.
I'm gonna still overrule the objection so she can answer the question for everybody to hear.
Now, it also says on your CV here on page 3 that you're involved in teaching. Can you explain to the board members what kind of teaching you have been involved in, for how long?
So pretty much my whole career. When I first started practicing medicine, for several years, I was a clinical professor with Georgetown University. And then when I opened my own practice, I was, precepting, medical students, and, I also trained, nurse practitioners, PAs, and medical assistants. And a large part of what I do right now with, mid-level providers is provide that teaching and provide that background, and they have a difficult case or they don't know what to do with the patient. That's my job. I'm always available to help.
If you would, turn to Hussein 5, please. This letter says Alluvian Health, and it's addressed to dear Sir Madden. Can you tell the board who Alluvian Health is and what this letter dated March 17, 2023 is about?
I can't find it here, but I do know what this letter is. So, Montana is, I'm sure you're aware, is a severely underserved state. So, they just don't have medical doctors to provide the care for their communities. So Alluvian is a whole, clinic that provides care for this particular part of Montana. And, I was, supervising the physician assistants, at the location and doing quality assurance and helping them basically provide care for that community.
Earlier, Mr. Barnes asked you some questions about the company that you use to, I guess, match you with collaborating physicians. How many, let me back up, your telemedicine practice has been separate and apart from collaboration for quite a while.
Yes, correct.
Now, once you started with the collaboration, how many different states have they matched you with? This company, what, I forget the name, what's the name of it?
Doctors for providers.
How many different states have they matched you with collaborating, nurse practitioners?
3,
In addition to Mississippi?
correct.
You remember what those are?
Yes, it was North Carolina, Oklahoma, and Mississippi. And Florida.
You also mentioned something about, COVID and COVID orders and what other states did and didn't require. And you understand that whatever went on during COVID and what other states required doesn't affect what this board can do or what their regulations are.
Yes, I understand.
Do all of these states that you have collaborated in have collaboration requirements?
Most of them do, yes, the majority of them do, absolutely.
And the person that you were matched with, we talked about earlier, was Eric Horton. You didn't know Eric Horton before this happened. did you?
I think.
If you would, look in the board's exhibits at MSB 24. That appears to be the CV or resume for Eric Horton. I provided this information to you previously. Is that the same Eric Horton that you collaborated with?
Yes.
Looking at her credentials here, how much experience did she have as a nurse practitioner, number one, which you could tell. Or did she have experience? Or say so.
Yes, she did have experience. She had a fair amount of experience as a nurse practitioner. And she had a lot of experience as a nurse.
And as far as the IV hydration, do you see it mentioned in here?
No.
But she had been practicing for, it looks to me, since, as a nurse since 2009. And then she got her master's of science in nursing in 2019. And became a nurse practitioner. All right. And look at the next page, which is MSP 29. Is this the collaboration agreement that's signed between you and Eric Cole?
Yes.
There was a statement made earlier by Mr. Barnes that you supervised Ms. Horton. Do you see anywhere in this collaborative agreement where it says that you would supervise her?
Well, no,
What's your understanding of the distinction between supervision and collaboration of a nurse practitioner?
but generally with collaboration, I'd be responsible for more of the medical, aspects. So, doing chart reviews, conducting, meetings periodically as required by whatever state. And just being available if there's any question or concern by the provider.
If you will, look under Roman number 1, scope of practice, about halfway down on 1, 2, 3, 4, 5 lines, and there's a sentence about 3/4 of the way across. It begins with nurse practitioner. You see that?
Yeah.
I'm going to read that for the record since I know there's an issue. It says the nurse practitioner, as a registered nurse, may also diagnose and treat human responses to actual or potential health problems through such services as case finding, health counseling, health teaching, and provision of care supportive to or restorative of life and well-being. In conjunction with wellness and health, the nurse practitioner will be providing intravenous hydration services, ion injections, and obesity management. This practice will take place at Resilient Hope Hydration Land. Did I read that correctly?
Yeah.
All right. Is that your understanding of the practice that she was going to be implementing, for which you were going to be collaborating with her?
Yes.
Earlier, Mr. Barnes asked you about, I think it was MSB 31, 32, 33, 34, and 35. The monthly chart reviews were shown on MSB 31, 32, and 33. What percentage of the monthly patients charts did you review for Ms. Horton's practice?
100%.
Are you aware of whether or not the Mississippi regulations require a review of 100% of the charts?
No state requires 100% review.
Why would you review 100%?
Well, she was having new practice. And I wanted to make sure that the standards were upheld.
In the course of your collaboration and review of 100% of the charts, did you ever see any indication of a patient complaint? Did you ever see any indication of a patient injury? If you would look now on MSB 36. Can you explain or just describe what that is for the board? please?
So I guess this was the letter that I wrote, kind of explaining, what had happened and when I had realized that there was a violation, because of course, I didn't know, the doctors or providers didn't know, Erica didn't know, we didn't realize we had violated the Mississippi, regulations. I basically tried to explain what had happened, and tried to make it clear that I didn't intend this to happen, and tried to really kind of put out my history a little bit in a summary.
And the date of that December the 11th, 2022. How and when did you become aware that there was a violation of Mississippi regulations?
I believe I received a call from somebody stating that there was a violation.
Investigated with the medical board?
I think so.
Move on to the next page, NSP 37. There would seem to be some question about what was being done by Ms. Horton with the patients. If you would, please read for the record, meaning on the 1, 2, 3, 4th line from the bottom on the right-hand side, which is Erica 9.
I'm sorry.
The 4th line from the second paragraph, 4th paragraph, 4th line from the bottom on the right says Erica 9.
Eric and I decided to be sure each patient gets a thorough medical history, vital signs, a focused exam, looking for signs of volume overload or circulatory issues. Lab work was requested as well for patients.
Is it your testimony that according to the record you reviewed in your consultation with Erica Horton, that was done?
Yes, it was.
Is there anything more that you're aware of that required for IV hydration therapy other than that in preparing for patient hydration therapy?
For Mississippi, I don't believe there's anything else. For other states, they really don't even, have this requirement.
Or no?
Cross-examination by the board?
If you turn the page, you know, this on the page, so have the guidance agreement with, is that correct?
Yes.
Who developed the guidance?
I developed it with Eric. We worked on it together.
Roman numeral 2, practice protocol. You know who wrote this?
Eric and I both wrote it.
The protocols used in wellness and clinic are currently cited on the Olympia Pharmacy website, Innovative Compounding website, and Power Pharmacy clinical guidelines and family practice, Uphold Graham 2013, Family Practice Guidelines, Passion Labs 2013, and those currently cited on the up-to-date and the cognitive educational site for the providers. Those all in the group. Those sites, they are agree.
Like, as far as,
What protocols you develop for having therapy. Wellness and management.
I'm not sure I understand the question. Sorry.
For any discrepancy, which one do you go to? Which one?
Well, if there's a discrepancy, I think Eric would probably call me and ask me.
Well, that's still in the paramedic position consequences. And so just like if you didn't supervise on that, you're required to be available for consultation with her. And you were the medical director, not of resilient, but of the, sorry.
Same day, no?
Same day.
Yeah.
And that's, so you were a medical director of value, not just clinical staff.
Correct.
Any redirect? Okay. Can we release your witness? You may call your next witness.
That's all witnesses would have to respond to.
Closing argument?
Well, I have rules, not there. Dr. Hussein is very professional. Dr. Hussein is the board. Dr. Hussein is also admitted that she violated the rules for at least 5 months. And this board, needs to take action to enforce its rules. What action is appropriate, of course, is decided by the board. And it's not my place to suggest, disciplinary action. However, the idea that primary physician did not understand that she had any sort of supervisory responsibility or oversight responsibility for many of the filing is concerned. It doesn't mean that primary physician is supposed to look over the APRN's shoulder every step of the way. However, chart reviews, quarterly UI meetings are supposed to allow collaborative physicians to identify problems with the charts. And the UI meetings, not just to identify problems, but to educate the middle level, pick out problems. Here's something that I want to focus on this quarter. Or here's something here I noticed in the records that I want to follow up on. If you look at the chart reviews, you cannot tell anything except that charts for those patients. That's it. No comments, nothing. It's come before. We don't have the medical records, but those chart reviews, those myths, it appears to say that the records are covered. So there's nothing, no problems, not whatsoever. And they look honestly like they could be simply partially documented. It's impossible to do. Well, I talked about the nursing board order. Notice that when the nursing board came to that clinic and asked their licensee, where are the documents? She said, I don't have them. Later, those documents were provided. Where those documents were, or even whether they ever existed at the time the nursing board payment visit, cannot be determined. Can be determined this. The nurse practitioner did not have the documents. Did not submit it. The nursing board saw this for recommending the workforce further. And violations there. The board has discretion to things necessary to maintain practice standards. Here to say.
Thank you. Closing argument?
This Barnes implies that every collaborative petition in the state owes a duty to supervise the mid-levels
that they collaborate with. I think that would be new to them if they're considered supervisors and not just collaborating positions that have to abide by what regulations tell them. This is about collaboration, not about supervision. That's the only point that I've ever tried to make. As far as the medical record that Mr. Barnes speaks about, the board had the power to subpoena those medical records if they wanted to look at them, if they thought there was a question about it. And the board is the one that has the burden of proving innocence or guilt. And she's admitted that she's guilty. That wasn't until the day when it happened, but there's no medical records here because the board simply didn't subpoena them. Or they may have them and they just didn't produce them. As far as what Erica Horton told the nursing board, the testimony is that she was visited, Erica Horton was, at a location that was not the resilient practice. The board's own documents say that the resilient practice closed when the nursing board's APRN director arrived. So she went to the other location where the nurse practitioner was located. You know, the nurse practitioner couldn't have those records, should have them at that practice location for her urgent care practice. That was not where she was doing IV therapy. It was another job that she had. The legislature, in their enabling language, they give this board the power to punish. If certain circumstances exist, they say that the board may revoke, suspend, or take any other action deemed appropriate. What they don't say is that this board is required to do so. That is this board's discretion. But discretion never used is not discretion at all. This is not an issue of competency. This is not an issue of case harm. This is an issue of a violation because the paperwork was not done properly. When Dr. Hussein relied on the company that she had relied on to handle her affairs in other states. Was that right? To completely rely on that company? No, it wasn't. It was a mistake. But she is licensed in 50 states and District of Columbia. And if you're going to levy a disciplinary penalty, I would ask you to consider the impact that it has. It won't just be an impact in the state of Mississippi if it's public discipline. It will affect her in every other state, just like a domino. I've handled other cases for other positions. I'm sure board members here have seen it, where positions have licenses in multiple states. And once it hits, the state bank, then every state is looking to mirror the action and follow suit. It gets complicated. If this is an issue of patient safety, it would be a different story. But here is simply, she didn't follow the documentation rules. She didn't submit what she was supposed to do. But nobody was harmed. There was no question about the competency of Dr. Hussein. When you look at the nursing board order, there's no question about the competency of Erica Horton, the nurse practitioner. The issue there was that she didn't get the site approved under their rules, like she should have. I just would request that the board balance things. Yes, the board's rules need to be respected. They do, but this board needs to be respected too, be honored. And it doesn't mean that every time that there's a violation, that you have to do something that takes care away in our society, in this state, in other states, which it could have that effect, especially in other states. So the balancing is what I think is something that this board should be interested in. And I would request that they do, and so that Dr. Hussein, in other words, we were waiting and deciding, okay, she's admitted a violation. So do we throw the baby out with the bathwater? Or do we issue her caution? Something that's not public. She's here today. She's admitted how she feels about this. But under these circumstances, it's respectfully submitted that Dr. Hussein not being disciplined with some reportable action. And I think under these circumstances, it's appropriate.
Thank you. Guys, want to proceed to the next hearing or would you need to? Do you guys have any, did y'all have any questions at all before we go back? Does anybody have any questions?
Go to back to the second.
Let's executive. Okay.
Are there any further questions at all from the board members as it pertains to this issue? Hearing none, I'll entertain a motion.
Yeah, I'll move to close the meeting and whether to consider whether to enter into executive session on this issue.
Second.
So it's been moved and properly seconded that we close the meeting to consider whether to go into executive session. All in favor? All opposed or any abstentions? And Dr. Kennard will read the findings or the executive the board's decision. Back in executive committee. Sorry.
Thank you. Recognizing Dr. Hussein's admission of the violation of Rule 1.3 and 1.4 of 2630, Chapter 1, the board will issue a reprimand. We appreciate your personal presence and testimony today.
And so with that decision being made, this hearing will be adjourned. This being adjourned. Oh, we do? So we don't.
No, I'm sorry. We got one
We
more.
got one more.
Oh, I'm sorry. My bad.
Shoot,
I was
hoping
like-
you were right, though. I was excited there for a minute. Uh, as soon as possible, but I can't tell you an exact date by which I'll have the order ready. I'll probably be skimming right close to that 30 days, to be honest, because I am out of town for a week, so. Mhm.
And violence. Oh, I think we could have done this 6 months ago and never put these on the agenda, and we would have wasted.
Yeah, but there's, yeah, I don't know what the strategy seems to be, but it's.
I'm not asking for it's not so.
What you need to do.
Okay, we're gonna move on to the next item of our agenda, which is a hearing in the case of Dr. Torgaba. Is that correct? Thank you. Dr. Torgaba.
Just so the record's clear, we just want to make sure that the record reflects that this is the hearing of Mississippi State Board of Medical Licensure in the matter of Dr. Torgaba, number 28866. And I assume the parties have already exchanged exhibits and have agreed to the introduction of some of those into the record.
I believe we already did it.
All exhibits. Okay.
I think license number 255669288.
Oh, okay.
It says 288.
It says 28866 on one of the continuances.
In the affidavit.
I'll apologize.
Yeah, because on the agenda, it says 25566 on the agenda.
On the affidavit, it says 28866.
So
Mhm.
25586. to be clear.
25566.
Six,
25566.
25566.
We're at Iron Auburn, members of the 1 through
40? Right, and respondent?
It was right. It was-
eighty-three.
There being no objection to either MSB's proposed exhibits or the respondents' exhibits, we will introduce into the record MSB 1 through 40 and Torgaba 1 through 83. You guys would distribute those exhibits to the board, please.
Is it wrong?
Oh. I think the coffee room there.
It does. Thank you. It does. But it did at least for me to watch. I have, I think, is this that the same thing? Yes,
Okay.
it is.
Everybody
Thank
did
you.
know that Jonathan Hoffman was away from the audio just to give us the minutes on it.
Yeah.
Two, and it
It is?
says 2886.
This is not
Yeah,
our fault.
it's 28866.
It is 28866.
It's the agenda that's.
Wow.
255, 288,
I give up.
Totally.
77793.
Par for the course.
We didn't know which one.
All lines is number five, so if you say more than that, it's not.
Yeah, so we have 28866 here, then we have 25566 over here.
On the agenda, it's 28866 on the continuance and the affidavit.
That is incorrect.
Right.
This is right.
Yeah, we figured this, we had the Great Seal of Mississippi. And then
Yes.
I'm gonna check this.
it's got the eagle on it.
Are the parties ready to begin move forward?
The blank house is great.
Would you like to make an opening statement?
Yes. While the board was out, of the room, just a very few minutes ago, the respondents came and talked about, notified me that we could use the rate of that program on the city, admit liability or admit to be violating the rule. And so, therefore, liability is not an issue. I would like to say, right off the bat, that it is a problem with MSB, the summit in this matter. Because it refers to, in the bottom of the first paragraph, refers to conviction of a felony or misdemeanor involving all substances. That is obviously wrong and inaccurate. If you look at the affidavit, the charges are stated correctly, which is simply that he was, his license was placed on probation by the state of California. That's what the only charge, the only charges are based on that. Before we got absolutely no reason. Here on the record, that is incorrect. And Mr. Shear, I agree. Make a statement that's reasonable. Yeah, perhaps it's respond if we believe that's.
Microphone.
If y'all could speak louder, I think that's the problem. I'm sorry.
On behalf of respondent, that's perfectly acceptable. We just wanted to make sure that there's no issue here with his conduct.
Thank you.
Dr. Florida had an instance where, he went to a seminar in Hawaii, paid for by the school hospital. And he got there and he stayed on a different island and, stayed, did not go to the seminar, stayed in Hawaii, came back. There was some, the administration originally, I believe, decided internally that they would not after a brief suspension, they were not going to report that for the California Medical Board, people would change it. And, the new department, down in that area, did report, that as unprofessional conduct, the California board, gave Dr. Fuller a probationary license. Like the last group, they certain, longer, lasted until sometime in 2024. I believe the other restriction, the primary restriction is a restriction on, collaborating with the provider. That's about a radiologist. No, I'm not sure what practical impact that has. So all I am asking for the board to do based on the violation, the violation of the board place, like for the Mississippi license on probation. It goes into California. Once you, produce evidence to the board, like the board of California, is being expanded, there's probation being lifted. This probation, will be lifted here. Yeah.
Ready to make your opening statement?
Always feel like, oh, Paul Harvey, now for the rest of the what Mr. Barnes said is, essentially accurate, but I won't rehash it, it'll come out during the testimony, I'm sure. There will be inconsistency of differences. The most important difference, I think, is that Dr. Portillo disclosed the issue with Hawaii, the trip, and the discipline that he received from the medical school. His application, we will go through and show, he disclosed that in his application to this board. And those facts, based on those facts, this board found that it was not unprofessional conduct, and they issued him a license. So, California decides that them warrants disciplinary action, so they disciplined him. And on that basis, and another state, Maryland, follows California. On that basis, Mississippi is the board staff to put this in front of you to say, well, even though he was issued a license, we need these facts. We think the mere fact that California and Maryland have now disciplined, on those same facts is good enough for you to go back now and discipline them, even though you fully disclosed in that application. So it's not anything that is intentional on his part. You'll hear his testimony of how this arose. It was not something that happened. He is remorseful for it. He is paying feeling for it at this point. This is a situation where the board, in my view, can do either one. They can follow the two states that decided to discipline him for this. Although this board is in a unique position, having considered it already, used the license. Or this board could say, well, we're going to go with five other states that have looked at this and decided no discipline should be warranted, including 3 jurisdictions who had hearings on it and said no discipline.
Thank you. Is the board ready to present its case?
Yes.
We may proceed.
Based on the documents that I already produced.
All right. Is the respondent ready to proceed?
Yes, responding to call Dr. Corbin, that's fine.
Dr. Targaba, you can step over here to the witness stand, and when you get there, please face the court reporter so she can swear you in, please. You just raise your right hand and repeat after her. Thank you.
Dr. Corbin, just for the record, will you state your full name, please?
My first name is Mayor, last name is Fonzie Torres.
Dr. Cordova, what is your current situation as a physician as far as practice?
So I have a position as a radiologist covering the states of Oklahoma and New Mexico. And I also have another position with the Veterans Health System, helping our veterans, and that office is in Shortland.
Can you tell the board in how many states you have a license that is restricted?
California and
Can you tell the board how many states in which you have an unrestricted license?
States of Ohio, New Mexico, Oklahoma, New York, and Washington State.
Out of those states, how many of them have been informed of this Hawaii incident that we
All of
All of
all
them.
of them.
if you look?
Yes.
Dr. Cordova, if you would, let's just start with, the first page on Cordova 1. You see that? Yes. All right. That's your license, correct? And what does it say is your license on this correct?
28866.
Thank you.
Thank you.
What does it say the date that, what was the date that you issued this license?
May 12th, 2020.
Now, let's go through the next set of pages, which are the 2 through 9. And that appears to be the application that you submitted to the board to reconsider remembering, making a decision to renew your license. When did you submit that application?
Around April 2020.
All right, what was your status at that time? Were you still, a resident? Were you,
I was a resident.
what year was it?
It was my fourth year of residence.
And there's questions in here under the affidavit section, beginning in part of 3 and going through part of 6, it looks like, or maybe more than that. Do you remember completing this application? Yes. All right. Look at part of 4. And about a third of the way down, there's a question. It says, have your staff privileges at any hospital or healthcare facility been revoked, suspended, curtailed, limited, or placed under conditions restricting practice? See that? Yes. And what was your answer to that? Yes. And you gave an excellent. We'll get to the explanation in a moment. All right, and then on the next page, up at the top, part of the 5, says during any postgraduate training, were you ever on probation, restriction, suspension, revocation, modification, or otherwise active against? Parentheses, explain otherwise actions spoken. And what did you answer to that? Yes. Again with an action. Correct. Correct. Awesome. Now, dropping down the page about halfway, there's another question. To your knowledge, have you ever been or are you now the subject of investigation or disciplinary proceeding by any licensing board agency as of the date of this application? Again, with an as I read this, those answers to those questions, they appear to be essentially the same, with a little bit of difference in this last one. There's some additional language. Can you tell this board what your narrative was in those answers to those questions?
Hello, good afternoon, everyone. So I explained the incident in the Hawaii conference. Unfortunately, the conference was held in the island of Maui, which was an expensive island for residents. So I made a mistake. I booked my hotel in the island of Maui, in the island of the other island, the Hawaiian island, on the thoughts that I can get some kind of ferry and commute between the two islands, and that would be cheaper. Before that, I used to live in New York City for 3 years. I had the experience of using the Staten Island ferry. Once I got there, I was told that there's no such option, and I have to commute between the islands only with a plane. And for a 5-day conference, it meant for me that I had to get 10 airplane tickets, which was quite impossible for me as a resident. So I could not attend the conference, and I was placed by my program director at the time. So on probation for 2 months, which I successfully completed, and 5 days of suspension. And that was the incident during the residency.
So that was your penalty by the program. And who was it that decided on that penalty?
Dr. Don was my program director, and
How do you spell that?
Don.
Spell it, please.
D-U-N as in Nancy, and S-E as
D-U-N-N.
correct.
And who else?
And Dr. Rosica was my associate program director at the time, R-O-S-I-C-A.
And where was that at?
They held a session during residency in Geisinger, Pennsylvania, and
All right, now, you've got some language that's a little bit different than two of the answers, they're essentially the same, but on page Geisinger 5, about 4/5 of the way down, on the left-hand margin, it begins March 2019 after my return. You see that? Correct. Could you read that for the record slowly, please?
in March 2019, after my return from suspension and consistent academic and professional improvements, I had a conversation with Dr. Dunn and Dr. Rosica, both of whom assured me this incident was considered an opening quotation mark internal matter, closing quotation mark, and did not need to be reported for licensing purposes. I have attached an email documenting that conversation. Based on that guidance, I did not disclose this information to the Medical Board of California. My intention was never to deceive or conceal the incident in question in anything. Please accept my deepest and most sincere apology for this assumption.
Thank you. Now, that was from the program director at that time. Now, later, another program director replaced Dr. Dunn. What was that program director?
Dr. Tryach.
And
Tryach, P-R-Y-L as in Larry, U-C-K.
now, before Dr. Pilot took over, what action had you taken in reliance on the representation made to you by Dr. Dunn, your program director, and Dr. Rosica, the associate program director?
Sorry, again.
What action had you taken? What have you done with that information? Have you made any applications?
Yes, so as a resident in Pennsylvania, we have to renew our residency training license once a year, every year, basically. So I renewed my residency licenses in Pennsylvania for my third and fourth years of residency. And I also applied to fellowship positions almost across all the country. And University of Mississippi was also one of the places that I have an intent to apply.
At this point in time, or excuse me, not this point, after that point in time, did you apply to California for medical license?
I applied to Medical Board of California when Dr. Prime was in office.
Now, whenever you apply to California, Dr. Dunn and Dr. Wasika had already told you that it was an internal matter that did not have to be disclosed on the licensing application. Correct. How many conversations did you have with them about this?
3 or 4 conferences.
And they confirmed to you in an email what they thought about that you submitted. Did you submit that email to all of the schools in which you applied, to medical boards in which you applied?
Yes.
Look, if you would, at what's part of 16. Can't hardly read the base number. I apologize. I don't have to take it. You have that in front of you? Okay, is this the email you're referring to?
Yes.
All right. It was difficult for me to read, even with my glasses, because it's so small, but it looks to me like this is an email conversation between you and Dr. Rosika.
Yes.
And she is the associate program of refuge stuff about a moment ago.
Yes.
What's the date of this email?
March 2019.
Okay. And down there at the bottom is her sending you information. And what I read, well, I'll let you read it for episode.
Hi, Mayor. I confirmed with Dr. Dunn that the situation was an internal matter and does not need to be reported for medical license. Period.
And just so the board's clear, that's the information that you relied upon in making your application in California. That's right. But whenever you apply in Mississippi, you fully disclose the incident, including this email, to Mississippi.
Yes, I did.
Let's take a look at your CV, which is sort of a 10 through 12. Don't want to spend a lot of time, but just enough so the board can become familiar. What are you doing right now? What's listed up here at the top? Or the top two, what are those?
Those are the positions that I currently have. I just mentioned one of them is a radiologist position for the state of Oklahoma and New Mexico. And the second one is the fellowship that I just graduated from University of Washington in Seattle. And the third one is the other position at the Veterans Affairs that I also.
And you said the Veterans Affairs?
Yes.
Okay. All right. Looking down there, I also see that you've had postgraduate training at Cornell and a postdoctoral research fellow in surgery at Cornell. What, I think something happened there that can you explain that? With the fellowship of Cornell, maybe I'm saying.
So I basically the fellowship at Cornell was a research fellowship.
Okay.
I did my internship in surgery at Cornell, then I switched to radiology. And then I have another fellowship in radiology that is, I just graduated from the University of Washington.
All right, and down below on the bottom, you list the licenses that you have. And if I look at it, you've got 1, 2, 3, 4, 5 unrestricted licenses. Is that correct?
Yes.
Wait, 6 county Mississippi. 1, 2, 3, 4, 5, 6. 6 county Mississippi, and you have 2 stipulations, California. What are those stipulations in California?
I should have a practice monitor, and I should be compliant, which I am. I should basically I submit cases on a monthly basis to my monitor. I do quarterly interviews with the Board of California. I send quarterly reports to the Board of California under purview. And I cannot observe PA or MPs. And I cannot practice solo. And I have to pay the costs of the probation on a yearly basis to the Board of California. Just I remember.
Dr. Caldwell, those restrictions or conditions that you just listed, mentioned, are every single one of them because of the incidents arising out of Hawaii?
Yes.
So there's nothing about inpatient care or competence.
Yeah.
All right. The last thing on your CV, if you look at Port number 12. Under honors and awards, the 3/4 way down, it says ranked 99 in the nationwide Iran University admission examination among over 1.5 million participants. So is that the 99 percentile?
That's the actual 90 months.
Well, that's actually 99 out of 1.5 million. I don't know how to calculate that.
51%.
Yeah.
That one.
Let's look at,
Excused.
let's look at part of 13, please. Could you explain to the board what this is?
So in radiology, you have two steps for getting certified. You have two exams. One exam is at the end of residency, which is called qualifying exam for certification, and the other one is the certifying exam itself. So I passed both of them, and I got certified by American Board of Radiology.
So the Board of Radiology, the board certified you, were they aware of the Hawaii incident?
Yes, they are.
All right, let's go on to Port number 14. And up at the top, it says to the Medical Board of California. Now, would you explain to the board what your status is now with the Medical Board of California and why you submitted this to them?
So I'm almost in 2 months. I have been compliant with 2 years of my probation with Board of California, and they have a law that after 2 years, if you are in good standing and if you are compliant with the Medical Board of California, you can submit a petition for early termination of the probation term. And I'm in the process of that, and we hope to lift the probation in California altogether at the 2-year anniversary.
All right, if you would turn now to Port number 17. This appears to be an email correspondence from you to this board. Can you tell this board why you sent this email to the board? What was the purpose?
I was initially notified during the application for Medical Board of California that they are going to issue a probationary license. So at that time, when I applied for the Board of Mississippi, I informed the Board of Mississippi on my Mississippi application about that. Once the California license was finally issued, in terms of reality, basically it got issued. At that time, I already had my Mississippi license, so again, I notified the Board of Mississippi that, as I had told them before, the Board of California has placed me on probationary license.
And so this here, if I read it correctly, you're saying that Maryland had basically done a mirror action in California.
As I told the board one more time again after that.
All right. Next in next is 18 through 24, which was just a consent order with the Medical Board of Maryland, correct? All right. And now then, Article 25 through 27 are just other medical licenses from New Mexico, Oklahoma, and Maryland, correct? Yes. All right, now let's look at 28. 28 says it's the New York State Department of Health. And I'm not really sure I'm understanding what's going on here. Did New York issue you a license and then they investigate, or did they investigate then issue your license? The first paragraph, I can't tell what they mean.
I disclosed the incident to them. They issued a full unrestricted license. They again investigated it again and dismissed it.
So you had the license from them, and they went back and investigated like Mississippi does now.
Correct.
And they allowed you to maintain your full unrestricted license. All right, then Formula 30 and 31 are Ohio licensure documents, and 31 mentions self-reporting to the board. Is that self-reporting the same line? Yes. Now let's look at Formula 32. Again, this is something from you email you to the city board. And it says update. Can you explain what you're telling me about this?
So this email is actually the explanation that I just said that once the California board issued the actual license, I can update the board of Mississippi about the probationary license in California.
So you're just making sure Mississippi knows what's going on. All right. And again, on Formula 34, there's another document that says it can be self-reported to the Maryland board and the California medical board. This is for the state of Washington. Correct. Right. And what did, well, let's look at it. The state of Washington sent you a document which is Formula 38. Can you turn to that? Yes. All right, read that first two sentences of that document.
The Washington Medical Commission received a report against you alleging unprofessional conduct. A panel of at least 3 commissioners reviewed this report and determined that it did not meet the criteria for authorizing an investigation. Therefore, this complaint has been closed.
So once again, this is the Hawaii that they're looking at, nothing new. So, now, Formula 43 through Formula 57 appear to be CME certificates. Is that the case? Yes. Can you summarize, were these required because of California and Maryland, or these just your regular CMEs?
Some of them were requirements by the Medical Board of California, and the rest of them are voluntary by myself. So one of the requirements by the Medical Board of California was that I had to complete around 24 CME of professionalism courses, which I did that. And in addition to that, I added another extra 12 professionalism courses voluntarily to prove that I'm willing to go beyond what is mandated by the Medical Board of California.
So these additional 12, you said, are
Yes.
they were voluntary by you, nobody
Yes.
required you. Okay. Formula 58 through 65 are letters of support. Let's take a look at these just briefly. The board can certainly take the time to read them later if they desire when they deliberate. Let's start with the person of Claire Sandstrom, MD, Seattle, Washington. Who is she and how do you know her?
She is my, right now she was She was my fellowship program director at the University of Washington.
In the second paragraph, the first sentence, she said at the time of his application, Mayor was upfront about his previous professionalism issue and was deeply remorseful. What is she referring to?
The Hawaii incident.
Do you personally know every one of these positions who provided a letter of support for you?
Yes, I did. I did my fellowship with also.
If you would, let's now look at Cordova 80 through 82. And this pertains to an order granting joint motion to dismiss out of Pennsylvania Board of Medicine. So I'm a little confused because you don't list a Pennsylvania license, but there apparently was an action and it was dismissed on April the 21st of 2023.
Correct.
Can you explain that to the board?
So Hawaii incident and issue with the Board of California. And so we went to the hearing with the Board of Pennsylvania and the case was dismissed.
Dr. Cordova, one of the matters that this board will decide is what disciplines to impose on you based upon the fact that California and Maryland have disciplined you. What detriments have you sustained or suffered so far as a result of California and Maryland imposing discipline? I guess we go all the way back to when this whole Hawaii incident first started.
So I was placed on probation as a resident. I lost my rest of CME allowance as a resident. I couldn't do any moonlighting as a resident. And basically I completed those requirements. As a third year of radiology residency, you apply for the fellowships on your third year. That was when I consulted my program directors at the time. I was offered multiple fellowship positions, and the one that I went into was, the one that I signed the contract with them was UC San Diego in California. And that's why I applied for a licensor in the state of California. Taking the license in California is very lengthy, and I had only 3 months left of my residency to the start of fellowship. And I had back and forth with the state of California when the license would be issued, and they said that you are going to give you a probationary license. If you disagree with our terms, it will go to the next board meeting. And because I thought I would lose my fellowship by then, I just signed a contract with California. And unfortunately, once I got the probationary license and I reached out to the UC San Diego, UC San Diego told me as a universal protocol all around the country for fellowship and residency, your license should be full unrestricted for fellowship. So I missed my position at UC San Diego in around June of my 4th year of residency, which was kind of unexpected for, and again, I had to apply for fellowships, which would put me behind for another year. I had to look for a job to fill that year, and as a physician, you all know it takes 3 or 4 months of credentialing for any position, even if you get accepted. And because I just graduated from my residency, I lost my healthcare insurance, and because of the probation in California as a radiologist, I lost the prospect of being hired by nationwide radiology companies, which usually require full unrestricted license in all the 50 states. And it was very difficult for me to find, near impossible to find the employer in the state of California because of the probationary California license. So the only way that I managed to be compliant with California terms was to get hired by the Veterans Affairs, which is a federal entity, and because of that, I'm still thankfully compliant with the Medical Board of California. Basically, any action by any other board would just start the domino effect of all the other boards. Basically, if I lose my VA job, I would lose my compliance with the Medical Board of California to train vicious cycle.
Cross-examination?
I think it would start another vicious cycle if more boards have giving licenses than have personal program.
Sorry, thank you.
You just said that you're afraid that if another board offers him different to you, it's going to start another vicious cycle of specific petitions. Why do you believe that?
Because I have to report any action by any authority to all the boards and all the entities, and they're all unanimous to investigate again. And even I have had that experience, for example, with New York, that they called me twice in a month from two people from the same department who hadn't talked with each other, and they didn't know that they already had investigated me just 2 weeks ago. So basically, they investigated me again.
It's already been reprimanded by merit. So on probation, it's all based on the why. Okay. Why do you think the California board decided that you were untruthful on your application?
Because based on the guidance that I had received from my former program director and former associate program director, as a resident, you know, all the physicians, as a resident, you do what your program director tells. And that was my mistake. And I did not explain to people that California, I accept responsibility.
Yes, appreciate your answer, but what really I was trying to ask, why do you believe that the medical board of California believe you had no false statement on your application? Why do you report it? Why did California take that so serious?
Because I mean, on the California applications, they have the same attestation questions that everywhere has. And I responded no to those questions based on the guidance of my program this at the time.
And you're referring to this, but are you referring to by the council of Hawaii? But we initially gave you a license when you were building the license. Correct. But it was not until November. That was in the spring of 2020.
Correct.
And then, but it wasn't until November. California on place your license on program.
Correct. I mean, that was the time that they issued the license, but they informed me sooner that they are going to take it.
Well, the residency program should be fairly serious.
They did.
But they immediately suspended. 5 days.
Correct.
With that. They considered terminating the residency program.
Yes.
They required you to pay the money.
Yes.
And you've already discussed that with the people. Maryland actually went a little farther than California in the sense that they did issue a form to the road.
You recommend that.
Yes, sir, but in California, it's not that. They do a probation and license. You discussed the possibility of early termination of probation in California. Is that automatic?
My California attorney says me cases like my case, I have a chance that they internally decide for it and it is handled automatically, but they also have the option of going to another hearing.
Well, so if this board were to simply place this license on probation, you got the California license, I think you're strictly, and California gave it, released you from probation early. Given the same benefit, I mean, you could provide this board with evidence that you would go off probation in California.
Obviously, when I'm done with the probationary term with California, I will notify all the boards. But in the interim, if I receive any other action by any other boards, I have to again report that to all the boards, and it would have probably a bad effect on the determination of the California decision. As I said, it's just like that.
So already based on the California and Maryland actions, you did not work for nationwide radio. So that would be, it would not be additional applications. This city simply mirror California operation. At least that. It's like. I'm looking at MSP, page 34. Turn it down. Very good. Paragraph 3. Specifically on February 24th, 2019, applicants training for the place applicant on suspension due to issues related to major professional work in violation of the program professional code of conduct. Applicant was also placed on probation on June 2019 following suspension for the same issues of profession. The applicant also failed to disclose the suspension of probation at California license application, which were required to be disclosed. So California should look at it. They go straight to the point. Correct. But after the program, make sure I understand. After the program director changed. Pricing? Try not. Fine. Okay. That follow up with this.
Yes.
Any redirect? Can we release your witness?
Can we?
Oh, I'm so sorry. I did forgot. Any questions from the board?
Mike. Mike.
So if they assess the case, if they're okay with it, they may not give me another hearing, they may automatically reinstate the license. If they think they have to evaluate it more, once the 2-year timeline has been passed, which is this November, they will hold their hearing. And I don't know exactly when they're hearing it. Yes. We have already submitted our case. They said we have received it.
Any other questions? No. Dr. Cleveland?
I'm just a little confused. Because you said you stayed on a different island for financial reasons. But it was your training program that's paying for the trip. Not you.
So as a resident, you have a cutoff. As a resident, you have a cutoff of $2,000 of CME money. So for a Hawaiian trip, the total cost was around, even staying on the cheaper island, was around 7,000, something like that. 2,000 of that was provided by the residency. If I stayed, for example, on the more expensive island, I had to add another $10,000 to that. But on the cheaper island, I had to add another $5,000 to that. So, I mean, the $2,000 of residency was just part of it.
And so you were on this other island, essentially alone.
Correct.
Nobody else you knew was there.
My wife.
Your wife was there.
Dr. Tornevi, I'm just want to get it straight. Your original residency director, Dr. Dunn, he said it's not reportable, but you had to pay the money back and you were on probation. But then the new residency director, Dr. Pryluck, said he's going to report that to the California board.
So,
And you're not aware of that?
correct. So as a general policy, Medical Board of California touches bases with all the program directors universally for everyone. And because I had already confirmed it with the program director at the time, I didn't think I need to go and basically relieve the incident again with the new program director. So the new program director was unaware of the incident. And once Medical Board of California had universally basically contacted the program director, they sent forms that program directors have to fill out with the same attestation questions that the applicants do. So Dr. Pryluck was not aware of the whole conversation with the former program director. And he had just went into my files and had seen that I was suspended for 5 days, and basically he had marked yes to the questions that I have marked in the for the Medical Board of California.
Okay. But you weren't aware of that until the Medical Board of California.
Correct. So I received this letter from the Medical Board of California that I found out that someone had disclosed it to the Medical Board of California. I initially touched base with my program director at the time, which is my former program director, Dr. Dunn. She said, no, I have not disclosed this as we had agreed. Then again, I reached out to Dr. Pryluck, and he said that, yes, I have disclosed it to the Medical.
Okay. So it wasn't necessarily malicious about the Pryluck. He was just filling out the form.
Correct.
Any other questions?
I guess, any questions based on the board's questions that either of you would like to ask? Complainant?
No.
So we can release your witness? You may step down. You can call your next witness. With the, Paul, would you like to make a close? Okay, respondent, closing? Okay.
There are no new factual issues. That are in the board's complaint. These facts have already been considered by this board. And they granted the license. The reason we're here is because California and Maryland decided that it was something they wanted to discipline the board. So it's not because of any additional conduct by the respondent. And when he said the whole cycle started again, I tend to agree with him because once it's reported, if this board provides discipline against him, once it's reported, then this why we're here today because in California and Maryland and the other states for which he has a full unrestricted license, may say, oh, well, the city's on something. So, well, let's have it here, have it there. But I think he's been honest, he's remorseful, he's tried to do everything he can and to do by California and Maryland. And he suffered a great deal. He simply is asking this board to weigh what's done and the fact that he full disclosure to this board in very good.
Thank you.
At this time, I'll entertain a motion.
I'll make a motion to move to close the meeting to consider whether to enter into executive session on this issue.
All right, any discussion?
Proud of you.
Look, I only took to the last one of the day. All in favor?
Aye.
Any opposed or abstentions? Okay. executive session, and Dr. Kennard, our Madam Secretary in waiting, will read the decision of the executive session.
Board finds that the complainant itself has not met its burden, therefore we dismiss the complaint.
Hopefully this helps you kind of put this behind you and keep moving forward.
Anything further from the parties? So with that, we'll stand adjourned from this hearing,
All right.
so we can be.
And, okay, so since the hearing is adjourned, and you're dismissed if you'd like to leave, at this point, I would entertain a motion for us to adjourn until tomorrow at 9. Recess, sorry, recess
Tomorrow at
until
9?
tomorrow at 9 o'clock, right? 9 a.m.
So moved.
All right, second. Yeah. All in favor? All right. See y'all.